So I'm going to be talking about driving registration and licenses and permits. When you look into the Constitution Act of Canada 1867, Article 95.2, you find the following there. It is written that it shall be lawful for the Queen, by and with the advice and consent of the Senate and House of Commons, to make laws for the peace, order, and good government of Canada in relation to all matters of regulation of trade and commerce. So here in the Constitution Act of Canada, Her Majesty granted the legislators, Her Majesty allowed the legislators to create enactments and regulations that control and regulate trade and commerce, according to Article 95.2. So now let's go and see in the enactment and in the regulation what they actually created. So we go to the Canada Transportation Act, and that's the enactment that they created, and we find the following. It is declared that a competitive, economic, and efficient national transportation system. Okay, let's stop there. So they're talking about a national transportation system. They're talking about our highways, right? Our highways and the roads that we use. And when they use words to describe it, terminology or designations to describe it, they use words such as competitive, economic, and efficient. Those are bringing forth trade and commerce. Those are attributes of trade and commerce. Now, it continues to say that the system that meets the highest practical safety and security standards and contributes to a sustainable environment and makes the best use of all modes of transportation at the lowest total cost is essential to serve the needs of its users. Well, let's find out who are its users as this video goes on, and advance the well-being of Canadians and enable competitiveness and economic growth. So here, the reason that they want to create a national transportation system is not to allow men and women to travel. It's not to allow men and women to travel to meet their needs, but to create something, a national transportation system that enables competitiveness and economic growth in both urban and rural areas throughout Canada. Those objectives are most likely to be achieved when competition and market forces, both within and among the various modes of transportation, are the prime agents in providing viable and effective transportation services. So when we first get into this and look into driving, into traveling, we see that it's being mentioned the fact that this is about regulating trade and commerce. They're saying that we need to create a highway system, a national transportation system that helps us to be more competitive and helps us to have economic growth and keeps in mind about competition and market forces. Again, this is all about a commercial capacity. This is not about a man or a woman traveling. This is about a commercial capacity. The application of this enactment. This act applies in respect of transportation matters under the legislative authority of Parliament. Now, a carrier in this enactment means a person who is engaged in the transport of goods or passengers by any means of transport under the legislative authority of Parliament. When we look into the federal enactment, we see that a carrier is described as a person, artificial person, who is engaged in the transport of goods or passengers. So, for example, you have a truck driver, okay? You have a taxi driver. You have a bus driver. That's what you think that they would be referring to only. Well, let's see. But that's what it's saying. A carrier means a person who is engaged, who is being paid to transport goods or passengers. So they are declaring that when you operate your motor vehicle, you are operating it from the point of view of a carrier, that you are involved in transporting passengers or goods in your motor vehicle, that you are involved in commerce. They actually use the word engaged. Carrier means a person who is engaged in the transport of goods or passengers. Engaged is a term used to denote or show forth that you have been hired or employed. Black Laws, ninth edition, engage, to employ, or involve oneself, to take part in, to embark on. So we're talking about a commercial transportation system. We're talking about the users who are going to be using these highways and these roads. And the ones who are going to be using these highways and these roads are going to be engaged. These carriers are going to be engaged. And what are they going to be doing? They're going to be transporting goods or passengers. The word person in the Highway Transportation Act has not been redefined. There is no contrary intention being brought forth concerning the word person. The person in this enactment is that subject and servant of Her Majesty. It is further being declared that this person is operating from a commercial capacity, that it is involved in commerce through the transportation of passengers or goods. Now, looking into the enactments, we find the following. The Manitoba Highway Traffic Act, it states the following. So we went from the Constitution Act of Canada into the federal enactment, which gave the governments the right to create the roads, and regulate the individuals. Now we're going into the provincial that flows down from the federal. And look what it says here in the Provincial Highway Traffic Act. A passenger vehicle means a motor vehicle, okay, classified or designated by a manufacturer. So the one who makes it, Ford, Hyundai, whatever vehicle manufacturer it is, and classified by a manufacturer as a passenger car, or which is designed, constructed, or adapted for the principal purpose of transporting passengers and includes a delivery car. This is the same definition that we see coming out for a carrier in the federal regulations. When we look up above here, it says in the federal regulation, a carrier means a person who is engaged in the transport of goods or passengers. And here in the provincial enactment, it says the motor vehicle, its primary or principal purpose is for transporting passengers, and it includes a delivery car, which would be the goods, the commodities. Now to go a little bit deeper, that was the Manitoba. Look at the Highway Traffic Act of Quebec. It states the same thing. The motor vehicle means a motorized road vehicle primarily adapted for the transportation of persons or property. So they're saying the same thing, but they're just wording it a little different. Instead of saying passengers, they're saying persons. Because when you know what a passenger is, it can be designated as a person. And then for property also. Now, the Highway Safety Code says a road vehicle means a motor vehicle, and a passenger vehicle means a motor vehicle. So they redesignated all to mean the motor vehicle, and a motor vehicle means that it's been classified for the principal purpose of transporting passengers and goods. So this is what's going on. When you arrive and you go and apply for a permit and you register your vehicle, they're designating it a motor vehicle, and they're saying that you're driving the vehicle. And when they say that you're driving the vehicle, they're actually saying that you are engaged in the transportation of goods or passengers. So when you use the definition of driving, when you say, I've been driving, you're driving, it's a legal term that they've concocted to mean that you are engaged in the transportation of goods or passengers. And when you see the definition of the motor vehicles that we are registering, it clearly states that the primary or the principal purpose of transporting of this vehicle is for transporting passengers or goods. Now, the use of the word primary must then indicate a secondary capacity, or even many subsequent capacities, or else why use the indication primary or principal, right? So when they give the designation or the description of what the motor vehicle is, they place a condition on it. They say a car which is designed for the principal or primary purpose of transporting passengers or goods. Well, what if I'm using the vehicle outside of its primary purpose? What if I'm using the vehicle outside of its principal purpose? What would my obligations then be to the enactment? Because apparently, from the beginning, when I looked, in the Constitution Act, in the federal enactment, and now flowing into the provincial enactment. What's being regulated is commerce. What's being declared is that I'm driving, engaged in my vehicle, and I'm transporting passengers or goods. And that's the reason why these vehicles were created, according to the manufacturer. But what if I'm only using my vehicle to travel and not to make a commercial gain in it? What is my obligation? As a man or a woman, a human being, we have inalienable rights, fundamental rights. And one of those rights are the right to movement, to freely go about and to freely move by any means that we want. Now, a driver's license is required. That's an inalienable right. Now, a driver's license is required for a person who is operating a motor, passenger, or road vehicle. That's what the enactment says. Driver's license required to drive the motor vehicle. A person may not drive a motor vehicle on a highway unless the person holds a valid driver's license of a class that authorizes the person to drive the class of motor vehicle being driven and carries the driver's license while driving. The first thing the law wants to do is remove your designation of man and women. So they're going to call you what? Give you a different designation, a legal designation. In this situation, it's going to be considered a driver. And what you're going to be doing, you're going to be driving. And what does that mean? That means you're engaged in the transportation of passengers or goods. You're making a commercial gain for this. You're engaged and you're driving your motor vehicle. The person that is being referred to here is strictly the artificial person, the subject and servant of Her Majesty. Her subject may not drive a vehicle unless it has the proper driver's license that gives them the authorization. Now we go on. Applying for a driver's license. A person applying for any class of driver's license must apply in the form required by the register. Pay the charge for the license that is specified in the regulations. So if you want to get a driver's license to be able to operate a motor vehicle, which means that you are engaged in the transportation of passengers and property, passengers or goods, and you're using their commercial highway to do so. That's the situation that you're putting yourself under when you register your vehicle. They're taking us out of our natural capacity and putting us under this commercial capacity. Now, the provincial governments have to charge for a driver's license comes out of the federal enactment, Financial Administration Act, Article 19.1. The governor and council may, on the recommendation of the Treasury Board, by regulation, prescribe the fees or charges to be paid for a right or privilege. You see that? For a right or privilege conferred by or on behalf of Her Majesty in right of Canada by a means of license or permit or other authorization by the persons or class of persons on whom the right or privilege is conferred. So let's backtrack this, okay? They're saying that we are classes of persons. Well, in this enactment, what classes of persons are we? We are considered drivers. We are drivers. And in order for us to exercise the privilege, because if you study the judgments here in Canada, they continually say that driving is a privilege. So in order for you to exercise your privilege to drive, you must pay Her Majesty in right of Canada, and she will confer upon you the right or privilege that you are looking for. And what you are actually paying when you register your vehicle and all this when you go to the motor vehicle is you're paying for a right to transport passengers and goods in your motor vehicle. And that's what they're regulating. And all this is taking you out of your natural capacity and is putting you into the commercial capacity. So when the police officer pulls you over, he's just following procedure. Always remember that. But he's seeking to enforce the enactment upon the driver, that class of person who has been given the privilege from Her Majesty to operate the motor vehicle, to transport passengers and goods. That's the legal position that you're finding yourself in. Now remember, It states the motor vehicle, its primary or principal purpose is to transport passengers or goods, and you'll be driving when you're doing that. Well, if you use it in your secondary capacity, then what happens? If you stand as a man or a woman and they continue to try and regulate you through the enactment, then you have to seek the administration of justice. Now, here in Canada, we look at the Supreme Court of Canada, a judgment from Gerald Mitchell, 2014, talking about the administration of justice. Section 8. The Charter itself contains no procedural directions. This led McIntyre J. in Mills to declare, the absence of jurisdictional provisions and directions in the Charter confirms the view that the Charter was not intended to turn the Canadian legal system upside down. What is required is that it be fitted into the existing scheme of the Canadian legal procedures. There is no need for special procedures and rules to give it full and adequate effect. When we mention that we are here for the administration of justice, it is the court's responsibility to take note and to fit this claim into the existing scheme or structure of the court. Okay? That's what the Supreme Court of Canada has said. These courts have the obligation, doesn't matter what court it is, according to the Supreme Court of Canada, if an individual is in that court seeking the administration of justice, they have the obligation to fit it into the existing scheme. That's their obligation. I've taken you over to British Columbia here in Canada, and we're going to play it out here just for a second. So I'm in British Columbia and I received a ticket from a police officer on the street. Obviously, he's trying to declare that I'm driving a motor vehicle, that I am engaged in the transportation of passengers or property, and I am making a commercial profit by doing so. If I challenge that and I say, no, hang on, I'm standing in my natural capacity as a man or a woman, and by you trying to force me into the capacity of a driver under that enactment, you are breaching my fundamental rights and freedoms as enumerated in the Charter, as enumerated in the Constitution Act of Canada 1982, and as enumerated in international law. Your enactment and your actions with me are stepping upon my inalienable, natural, fundamental rights and freedoms. The guy would issue me the ticket, and I would have to show up to court. And look what happens here in BC. Traffic and bylaw matters. The most informal proceedings in the provincial court involve traffic and municipal bylaw matters. You can act as your own lawyer to dispute a traffic for infractions like running a red light, speeding, or parking violations. You can also dispute bylaw offenses such as walking a dog without a leash. The provincial court has jurisdiction, legal authority, in all traffic and bylaw offenses, as well as all other provincial and municipal offenses prosecuted under the Offence Act and the Local Government Act. Many of these offenses are prosecuted by the way of a violation ticket or a municipal ticket information. Judicial justices generally hear these cases. The judicial justice will explain and guide the hearing process, but cannot give you legal advice. On your court date, be prepared to conduct your trial if you plead not guilty. So you got your ticket, you pled not guilty, you weren't operating in a commercial capacity, why should they be regulating you? Now you show up for your court date. Now, it states, if an issue under the Canadian Charter is raised, the matter will be adjourned. It will be stopped right there to another day for a provincial court judge to preside over. So in BC, if you get a ticket and you stand up for your fundamental rights and freedoms and you say, listen, you're regulating me as a driver in an enactment and you're claiming that I'm making a commercial gain here when that's not my capacity. That's not what I'm doing. Where's your proof that I've been engaged? Where's the proof that I'm making money? And far above that, that's not my capacity. Therefore, I'm invoking my fundamental right and freedom that I want to stay in my capacity as a man or a woman. They will suspend the court and they will send you to the provincial court for another judge to preside over. That's what this provincial court system is doing here in BC. And that's contrary to what we just read concerning the Supreme Court of Canada. The Supreme Court said, listen, you smaller courts, you inferior courts, you have the obligation to fit in the administration of justice within your process. But here BC says we're not fitting it into the traffic court. We're not going to fit it into this lower court. We're going to keep it a statutory court. For those who understand what I'm talking about now, instead of allowing the inherent jurisdiction to operate in that court, BC says, no, we're going to keep it as a statutory court, and we'll shut you down right now, and we'll send you to the provincial court, the superior court, where there's inherent jurisdiction to hear your charge. And this is against what the Supreme Court of Canada is saying, what that must transpire. So if I was going to raise an issue, a constitutional challenge, constitutional question against why they're claiming that I'm operating in a commercial capacity when I'm just operating in my natural capacity, they would shut down the court in BC and send me to a higher court, which would take longer to deal with the situation and cost more of my time and more of my money, not an effective means for remedy for my behalf. I want to bring you over to Saskatchewan, another province in Canada, and bring you to the Constitutional Questions Act. This is the enactment that allows us to walk into these courts and challenge these enactments. And if you look here, it says current version in force since May 16th, 2012. So they produced a new version and they gave it royal assent on May 16, 2012. The old version was in operation since 1978, the old version. Now when you scroll down here, in part 3, talks about notice on constitutional questions or challenge to regulations. So I'm going to challenge your regulation. Your regulation is declaring that I am operating as a driver, that I am operating a motor vehicle, engaged in commerce, being paid to transport passengers and goods, commodities. And that's not my designation. I'm a man. I'm a woman simply traveling. So I'm going to challenge the regulation and I'm going to challenge the ticket. Now, interpretation. In this part, court means the Court of Appeal. So you can do a challenge to the regulation in the Court of Appeal. You can do a challenge to the regulation in the Court of Queen's Bench. You can do a challenge to the regulation in the Provincial Court of Saskatchewan. Or you can do a challenge to the regulations in the Traffic Safety Court of Saskatchewan. So Saskatchewan is fulfilling their obligation according to the Supreme Court. The Supreme Court said, Gerald Mitchell said, you guys have to fit it into your court structure. If someone comes seeking the administration of justice, claiming that there's been a charter abuse of their fundamental rights and freedoms, you have the obligation to fit it into your court structure. BC hasn't done it yet. Their traffic court doesn't deal with the administration of justice. But here, when you look at Saskatchewan, in 2012, they updated their enactment and now they provided the measure or the means for individuals like you and I, if we understand our rights, to go into the traffic court and to invoke the administration of justice. Now, if you look into the old regulation from 1978, and you go and you click there, there's no mention of traffic court. It was mentioned differently. The way they talked about how you could do a constitutional challenge was mentioned in Article 8.1. It talked about what a law was, and it talked about you could seek for a remedy, as according to Section 24 of the Charter of Rights and Freedoms. But it didn't allow you, this is the same, what you're reading here, all this here is the same operation of law that's going on still in BC. BC's under this old operation of law. However, Saskatchewan went and updated their statute to fulfill their obligation according to the Supreme Court of Canada. And this is good. Why? Because it allows, again, like I said, individuals like you and I, who understand our rights and freedoms, to now, once the police officer have violated our rights, to go inside that traffic court and to seek the administration of justice and to put a stop to it right there. And that's what we see happening, not only in Saskatchewan, but we see it all over the provinces in Canada. Those who understand what is going on and go into the courts and express their rights and claim their rights and show to the judge that there's been a breach of the administration of justice against them, that they're being forced to play a role in an enactment that they're not even partaking of. I woke up this morning, Judge, and I was going to see my grandmother at her house. And yeah, you know what? I was doing 70 in the 50 zone. No one was around. It's a quiet street. That's not the point. The point is, I was going to see my grandmother. I was not involved in commercial capacity. I was not transporting passengers. No one had paid me for a ride. I was not transporting goods. No, no one is paying me for me going to see my grandmother. But yes, yet this police officer pulled me over and tried to put me into the enactment. He tried to place me into the enactment to make me play the role and designation of driver, to make me say that I'm transporting passengers and goods and that I'm being paid for this, and therefore he had the right to regulate me. And all this interaction with him is a breach of my fundamental rights and freedoms. It's a breach of my charter rights. And now you can seek the administration of justice in Saskatchewan. There's a few other in the traffic court. There's a few other provinces that you can, but for the sake of time, depending on your province, just go check yourself and you'll see. Because if not, then you're stuck in the old system as BC, where you go into the traffic court and you say, I want to invoke my right, and the judge says, whoa, I shut you down. I'm only a statutory court. He's not going to say it that way. He's just going to point you to the provincial court and say, do your claim there. But what he's saying is, I'm a statutory court. I don't have the inherent jurisdiction to deal with the administration of justice. I can't recognize your natural inalienable rights. Therefore, I can't hear this. Therefore, I'll shut it down and I'll send you to provincial court. That takes extra time. Again, that takes more effort and more energy on our part, and that's not an effective remedy. Here is the effective remedy. As Gerald Mitchell said, you go to the traffic court, you invoke your rights, and now the traffic court has the power to deal with the administration of justice. It can access inherent jurisdiction and not just remain a statutory court.